269 candidates have been effected. Such cancellation has not been interfered with by the division bench. The division bench has referred to prima facie materials which point to a fraudulent exercise connected with their appointment. On behalf of the respondents, however, no material has been shown to us through which these candidates' direct complicity in the process of appointment has been shown. Very crucial. What weighed with the learned single judge in directing their termination in a case where they were not even parties appears to be materials that were revealed in response to orders of the court. Such orders reflect some kind of investigative role that was being undertaken by the court itself in obtaining documents from the recruiting bodies. It was also not a case that respective appointments were of very recent origin. The duty of the judiciary to follow principles of natural justice and divine retreat, etc. My lord, para 14, if your lordship will come to. We are of the opinion that the part of the order of the single judge by which appointment of 269 candidates was terminated ought to be stayed. They should be implemented as party respondent. Upon giving them full opportunity of filing affidavit and hearing them, the single judge shall take appropriate decision depending on the defense that may be taken by these candidates in the writ petition. In the event the single judge wants investigation as regards to the appointment to be conducted through the sit already formed, he may direct so. So then, your lordships, at 356 para 16, set aside, stay and keep in abeyance the order of the single judge. And then at page 357 on the top, your lordship says, each of these 269 individuals are directed to be added as party. They shall be entitled to file affidavits to defend their appointment if so advised. Appointing authority will proceed in accordance with law, take appropriate decision after the writ court adjudicates on the legality of their appointments. So the writ court was to adjudicate on the legality of our appointments. What the learned single judge does, I will show the orders. The learned single judge feels as if this formality has been thrust upon him. In days we are impeded, the police officers are asked to serve us, we are brought before the court, and our affidavits are seen, and post haste, the order is passed terminating our services again. Now kindly see those orders of the single judge. Your lordship's order is 18th October 2022. After that, the first single bench order is 4th November at page 359, the very next page. Honorable, page 360. Honorable Supreme Court of India has directed the following, then those that we are to be party. Accordingly, the name of 362 persons have been supplied by the West Bengal Board of Primary Education. Petitioners are directed to add them as party respondents by 9th November. So this is 4th November order. The petitioner shall supply 3 copies of the application with amendment clause so and so. It shall be the duty of the board to serve copies on the writ application to the 262 candidates by registered speed post to collect the track report or acknowledgement due cards as the case may be for filing affidavit before 25th of November. The board shall dispatch such copies of pleadings to the added respondents by 18th November. Directions for service by the board is passed and it has been submitted that petitioners are very poor, unemployed person, etc. The board shall remain very careful in such service. The matter will appear on the list on 25th November. For knowing about the service, it will appear under to be mentioned. On that day, the persons who have been added as parties today and would appear before the court would be given direction for filing affidavits for defending their appointment. It is already indicated by this court to the learned advocate for the parties. Hearing of this matter will continue from Monday to Thursday, every week of the day, when hearing will start from 4 p.m. to 7 p.m. to complete the hearing as quickly as possible. I mean, there is some kind of a tearing hurry in the mind of the learned single judge to overcome this problem which the Supreme Court has posed, my lord, by making us parties, it appears. Then, my lord, the next order is 25th November at page 365. Now, the learned judge now had posted it on 25th. Now he says at 366. Today, learned advocate for the board has submitted one affidavit of service, wherefrom it appears that some added respondents have been served. in respect of some service is not complete. However, today those 6 advocates, learned advocate, 127 have appeared. I direct the respondents to file wakalatnama in the course of the day to supply the serial number to the advocate for the board. Respondents shall file their affidavit by 14th, reply by 21, matter will appear by 23, etc. Is directed to file another affidavit of service. Then, my lord, comes one more order at page 370, where in between the matter is taken up on mentioning. Huh? Yes, I'm going. That's why I want to leave. Side line. Just, my lord, I don't know. 371. Please read these two, 3 paragraphs, my lord. There is, I mean, that shows the mind of the court also. I mean, I have nothing against the learned judge, my lord, but my only problem is in the process I am getting crucified. So I have a problem about my crucifixion. Page 371. This is an application for addition of party filed by one Mr. Koena De, who had made some allegations against one Ghosh, who is already a party to the main application. From an order passed by this court on 19 July of the application, it is found the said Ghosh is already a party. I am told by Mr. Bhattacharya, learned counsel for CBI, that he has been interrogated. I find in this application for addition of party of Ms. Koena De has made some serious allegations against Ghosh. One of it is that Ghosh has found himself as a person with academic qualification between 8th and 9th in his passport application form. He is acting as a teacher. If this is true, the education qualification of Ghosh, this court fails to understand how Ghosh is acting as a teacher. He does not have qualification. Another allegation made for addition of Koena De is that Ghosh was acting as teacher, is also vice chairman of the municipality, and stated from the bar he is drawing 7,000. It is submitted he is not known whether he took any leave from the employer. Such allegations are serious. Besides this, the applicant, having training qualification of being a teacher in a primary school, did not get appointment because of huge corruption in the working of the primary school in which Ghosh is one person. In this organized crime, Shri Ghosh has also collected, it has been alleged, several lakh of rupees from candidates for giving them appointment. Allegation of collection is as of now without any particular. In the circumstances, there are some serious allegations. I direct Ghosh to appear before this court personally on 16 December at 1 p.m. And I direct the petitioner to serve copy of the application on Ghosh, either by hand or post. I direct the learned advocate for the state to intimate immediately the commissioner of Barakpur Police Commissionerate to communicate this order to the local police station of Ghosh, being so and so. And he has to appear personally at 1 p.m. etc. So this is how it is going on, my lord, in such a surcharged kind of atmosphere. All right. Then, my lord, kindly see this order at page 376.
Where are the termination orders?
I'm coming. Now, some people could not be served. The police was directed to serve them. Just have this page 376, 377. I'll read this order. Just see page 376, 377. In the first affidavit of service filed by the West Bengal Board of Primary Education, total, your lordship got 370. In the first affidavit filed by West Bengal Board of Primary Education, total 268 copies of relevant pleadings were dispatched, out of which 127 persons appeared. This court directed the board to file second affidavit of service, as service of rest of the persons was incomplete, as it was found from the website of India Post. Today, the second affidavit of service has been filed. From what it appears now, 130 persons have received pleading. Therefore, total 257 have been served. Service upon respondents, this 7580 so-and-so is incomplete, as there could not be effected. Postal packets have come back. Though I find from the photograph of the envelopes that full address available from the board has been printed, then it has been stated by the postal department due to inefficient address could not be located. Respondent 7 is one Sampa Samatra, whose postal address is given. I direct the superintendent of police of the district to intimate these persons through local police station, to intimate immediately that they appear on 22nd December at 2 p.m. I direct the Registrar General to communicate the order to the Superintendent of Police. Then what the learned judge does, whoever files affidavits, his case he fixes and he passes order terminating their service. So therefore, the termination order is in 3 different parts. The first order of termination is on 23rd December, where 50 persons are considered. Second order is 4th January. My learned friend is appearing in that, my lord, where 146 cases are considered. And the 5th order is 5th January, where the balance are considered.
Which page?
Now I'm coming to that. Just have page 378, one more para. Para 8. After telling the police to serve us, then have para 8. Mr. Das Gupta, learned advocate for the petitioners, has submitted that out of 127 persons served for which first affidavit in opposition was filed by 29 persons in time, 97 have filed their affidavit today, which are kept on record. It was made clear time and again that any pleading beyond the time limit fixed in this matter, where genuine candidates are roaming around the street with tears in their eyes and not genuine candidate drawing salary, will not be accepted. If some candidates think this court is a place like Children's Park, they are really mistaken, and such delayed service of pleading shall not be accepted by the court, etc. So, my lord, this is the kind of mindset the court is having, my lord. Now, kindly see the impugned order. That is at page 1, the first order of termination. The Honorable Supreme Court, page 2, my lord, I am reading. Your order 146, 4th January, 146. In your order. The Honorable Supreme Court, by order dated 18th October 22, so and so, other matters, have directed the writ court to adjudicate on the legality of the appointment of candidates. These 269 candidates were directed to be, this is all formal, my lord. No further opportunity. Some learned advocates have come today with affidavit of some added candidates, para 3, are accepted though delay, and their matters would be considered along with others who will file their affidavit. So and so. For giving them an opportunity of hearing. I pause here. Now this order is longish because identical 10 paras will appear for each of these respondents. So I will read the first 10 and then the same 10 will go for the next, same 10 for the third, same 10 for the fourth. That is why the order has become a little lengthy. So I will read for one only, the 10 to 12 paragraphs, which go, from 4 it goes to 12. So let me read the whole of it, my lord. It's just 3-4 pages. Now this is for respondent 38. If your lordship will note para 4, the first one being considered is 38. My lord has noticed that. Affidavit of service filed by respondent number 38 be kept on record. The respondent in reply to question of the court. So now affidavit goes. Has submitted. There
Sorry,
is
which
no,
are you reading?
I'm reading page 4 of the SLP paperwork. I'm sorry. That's
No,
very
no.
crucial.
Page 4 is okay. Today the affidavits of following respondents so and so
So and so have been filed. I have
Right.
taken on record, giving them an opportunity of hearing to defend their appointment.
Right.
Then I had pointed out, my lord, the cases of these respondents are considered by this order, which is impugned in this SLP. Now, this order, there are about 15 to 20 paras for each respondent, which are verbatim repeated for all the respondents, then one by one. So I'll read the first. Today, first he considers the first one, number 38. So para 5 now. Your lordship sees the title of this part of the judgment. It is respondent number 38.
Right.
Your lordship has?
Yes.
Yes. Now the consideration of 38's affidavit case starts. Affidavit of service filed by respondent number 38 be kept on record. The respondent in reply to the question of the court has submitted that there is no application or representation for giving him 1 mark against 1 wrong answer key. The court said, please produce it. Give it to me. He said, I don't have it. And this is what is being recorded. His affidavit in response to the petition, I will read just now what he says. The respondent in reply to question of the court has submitted that there is no application or representation for giving him 1 mark against 1 wrong answer key. The respondent has also not been able to show that at any point of time, the West Bengal Board of Primary Education intimated him that he has qualified in teacher eligibility test after giving him 1 mark. He lacks these 2 fundamental documents to defend his appointment. While defending his employment by opportunity given to him by none other than the Honorable Supreme Court of India, respondent has failed to produce these 2 fundamental documents. The first of these 2 documents, one would show his appeal to the board in awarding him 1 mark. Other one is the board's communication that against his appeal, board has granted him 1 mark. These 2 are absent. Therefore, board's granting of 1 mark to the respondent was wholly an affair which was secret and clandestine with such candidates to whom such benefits were given for reasons best known to the board. The chairman of the board is now in custody, arrested by the Enforcement Directorate for a number of financial corruption charges as the previous chairman of the board. There cannot be any clandestine and secret activity to give benefit of employment to a handful of candidates whose salary and allowance is to be paid from public exchequer. Transparency must be maintained. The respondent's affidavit is full of irrelevant facts which do not support his employment, where teachers' salary are paid. Mr. Das Gupta, advocate for the petitioner, submits that when TET was published, it was found that respondent was not a qualified candidate. Mr. Das Gupta has demonstrated from a laptop computer the names of 42,949 candidates who qualified. We have placed the printout of this 42,949 in our volume 2. It only contains 42,629 names. 300 names are missing, which are us. So, but in any case, my lord, in all this, where is the consideration that those proceedings of the meeting which took place on 27th, the meeting which took place on 30th, the affidavits asked to be filed by the court whether meeting was genuine or not. Court says, show me your application. The application is not shown and out he goes. And my learned friend was appearing, my lord. She has something to say, my lord. She would tell your lordships what happened actually. I was not there at that time. Now, so Mr. Das Gupta says, sir, this is my computer. I have 42,959. Ask them to find it from here. That candidate is looking in the court, in that laptop, what will he find there in the court in such a surcharged atmosphere? Later we found 300 names were missing from that computer. Now, if this is all, then after that, my lord, comes that you will be thrown out, no salary, no this, no that. Now all those will start. Para 7. Page 7, para 8. Respondent has shown one letter issued by the secretary of the board to the chairman of the Hooghly school and so, where it has been stated that one additional panel, which is actually a second panel and not additional panel, as additional panel is different under rules, of trained candidates approved by the board has been annexed to that letter. There is no power given to the under the rules to publish any such second panel. Preparation and publication of panel is illegal, a result of secret and clandestine affair adopted by the board to give employment to a handful of candidates in 2016 recruitment process. The problem is the learned judge quotes a proposition and then answers it without giving us an opportunity of saying what we have to say against it. Where is the discussion of what we say and why what we say is wrong and needs to be rejected? There is nothing here. In fact, my learned friend said she was muted. She couldn't even say anything. But where is this? These are all, one line is a proposition. Second line is fraud, clandestine, out you go. There is, the judgment has to contain a discussion of our pleas and rejection of our pleas. There is nothing. Just see para 9. There is no power. My simple answer is power to frame will include the power to correct an error. If there was one, and your lordship is aware, there are hundreds of cases before your lordships where your lordships have said, if answer key is wrong, it has to be corrected. There is no question of there being no power. The learned counsel for para 10 now. The learned counsel for the West Bengal board was invited to make a submission. When he has submitted, he has nothing to submit except saying that the secretary has filed one report in the form of affidavit affirmed in June 22. That I just read. The report was filed long back before the order of the present order of the Supreme Court. The board has not used any separate affidavit in respect of any of the respondents. Thus, the board has now not approved the employment. Board has not said anything during the hearing that he is supporting the employment. The affidavit fully supports us. The board is here supporting us. And the court says board is not supporting. Maybe the board got scared also, my lord, for all you know. The way how proceedings were going on, maybe the lawyer said, no, sir, I have nothing to say. It's quite possible it could have happened. It happens, my lord. In the affidavit of if the learned judge is recording it, then I must say it must be correctly recorded. In the affidavit of the board affirmed on 14 June, the board inter alia submitted that board received representations which is wholly untrue and false. But on what basis? Therefore, I am saying a proposition is stated and a reply is given. The board has failed to show any representation. The affidavit of the board also says the expert committee opined that answer key was wrong, which is wholly untrue and false, which comes to light when the court had directed production of record and perused the record. In the earlier stage of this proceeding, it has come to light that there was no expert committee formed by any authority. There is no question of giving any such opinion by the expert committee. But I can understand if this is a fact, but on what basis is it being said? The board is also said in the affidavit that after receiving opinion, it decided to award 1 mark to the unsuccessful candidates. This is a false statement, which has again come out on perusal of the record as aforesaid. Which is that mysterious record, my lord, is the question I ask myself. It's nothing here. There is neither any representation which was placed before the court at any stage, nor any testimonial, etc. This respondent has failed to produce his representation. Board has not filed any affidavit in respect of the affidavit given by the respondent.
Just a minute, Mr. Now they are saying that there is no representation also. Your case is that there was a representation.
Correct?
So you must have signed some representation.
Yes, we put it in the Dropbox note, which was the normal practice. Oh,
Where-
it's-
Where is that
The
representation?
board says it had received the representation. And and I will now read the writ petition of the petitioners.
No,
What
but-
they say.
Now the thing that is, we had asked the board to file a detailed affidavit.
Yes,
Today we have the detailed affidavit of the board before us.
correct.
The representation is not there.
No, board says it is there, but the record is not available.
Oh, that is very funny.
Different thing saying representation is not there. Board says it is there, but the record is not available. The board therefore says representation is there, but the record is not available. They were and writ petitions were filed, Manoj. How do we wish away the writ petitions now? But I am on a more fundamental thing. Somebody has a problem with my appointment. I have to be given a notice of what they want from me. I cannot defend myself in the air saying it's fraud. So what do you have to say? I will say it's not a fraud. Somebody says you did not represent, then we will get some answer, we will get some response. You cannot do it like this, Lord. You cannot throw out people who are in confirmed appointment like this. And in one line, shall not enter the school premises. Kindly see para 15.
So what is the board stand on this representation?
Yes. If a board says we have received it, your lordship may see that
No,
in
then
both the affidavits.
if a representation is received,
And my lord,
If we proceed on-
and I'll tell your lordship one other thing.
Mr.
Sir,
Atwalia,
Let us see.
if
yes.
a representation is received, and even if we proceed on the basis that because of time lapse they have been destroyed, there must be some registry where it is reflected.
I will respond to it. The real proof is of a document which comes into existence prior to the arising of this controversy. The real proof is of a document which comes into existence prior to our getting that one mark. Now, please see page 128 of the board's affidavit. That is the real proof. What is the truth and what is a lie?
No. If you are showing us this affidavit today, the first affidavit which you had read, which was an annexure,
Correct.
was please read para 7 of that affidavit, page 15.
I will read it not first, then I will request your lordship to come to page 128.
So,
I will first read
Let's
para
send it
7.
on the way.
Yes.
It
Para
is-
7 I'll read it.
Para 7.
After completion of the affidavit which is filed by Mr. Kunal Chatterjee, my lord.
Right.
Your lordship may have that at page 15.
1-5.
Yes, my lord.
Yes.
May I read?
Yes.
After completion of appointment of the impanel candidate, the board received representations from both trained and untrained candidates questioning the correctness. What to say of this, my lord? They have a number. Kindly see at page 16, para 13. The board received representation from 2787 candidates.
But you could have annexed just one. They could have just, this is
My
like,
lord, I'll tell your lordships what I was first going to show. Please have page 128 with me. Yes.
Same affidavit.
For 4 years,
Uh,
some of us have kept me there.
Yes, that also, I'll say that. Now kindly have page 128. This is the notice for the emergent meeting. This notice comes into existence on 16th November 2017.